Do you think that because you already missed your FBAR filings, it's too late to fix this without getting destroyed by the IRS? It's not. But here's what is true. The options available to you right now will not all be available to you 6 months from now. The IRS has more tools than ever to find unreported foreign accounts, AI, global bank reporting, international data sharing agreements. And once they find you first, the path forward gets dramatically harder and dramatically more expensive. What you do in the next few weeks could be the difference between a manageable fix and a financial catastrophe. If you've already missed FBAR filings 1 year, 5 years, 10 years, and you're trying to figure out what to do next, call us right now before you do anything else. Call us at 855-900-1040 or visit silvertaxgroup.com for a confidential review. The steps you take from here matter enormously. The wrong move can make this significantly worse. I understand what you are going through. I'm attorney Chad Silver, founder of Silver Tax Group. We help U.S. taxpayers with delinquent FBAR filings come into compliance before the IRS comes looking, and we defend them when the IRS already has. I want to walk you through exactly what happens when you file FBAR late, what the IRS can do about it, and what your real options are in 2026. In this videos, I'll be telling you what the IRS actually knows. The single most important distinction in your entire case, willful versus non-willful, what the penalties actually look like in real numbers, and the programs that exist to fix this, and exactly which one applies to you. Section 1. What the IRS knows and how they find out. FBAR delinquency used to be something people could quietly ignore. That era is over. Under FATCA, the Foreign Account Tax Compliance Act, foreign financial institutions around the world are required to report U.S. account holders directly to the IRS. Banks in Switzerland, Singapore, Canada, the UK, India, the Cayman Islands, they are all reporting. If you have a foreign account and you are a U.S. person, there is a very good chance the IRS already has data about that account sitting in their system right now. On top of that, the IRS has invested heavily in AI-driven compliance tools that cross-reference FATCA data against filed FBARs and 1040 returns. The gap between what they know and what you reported that gap is exactly what triggers an examination. I spoke with a client, we'll call him Michael. He had accounts in Germany he'd inherited from a relative. He'd never filed FBAR, never thought about it. One day he got a letter. The IRS already knew about the accounts. They weren't asking if the accounts existed. They were asking why he hadn't reported them. That is not the position you want to be in when you're starting this conversation. Michael called us in time, but barely. Section 2, the most important distinction in your case. Willful versus non-willful, and why everything depends on this. When you file FBAR late, the IRS makes a determination about why. That determination drives the entire penalty calculation. Non-willful means you didn't know. You weren't aware of the requirement. You made an honest mistake. Maybe your CPA never asked about foreign accounts. Maybe you moved to the US from another country and nobody explained US tax obligations. Non-willful is the better outcome, and for most people who call us, it's the accurate one. Willful means the IRS believes you knew about the obligation and chose not to file. Here is the part that shocks people. Willfulness doesn't require proof that you deliberately hid money. The IRS can establish willful blindness, meaning you should have known, had the means to know, and chose not to look into it. Here's what makes this dangerous. Your own 1040 return can be used against you. There is a question on Schedule B that asks whether you have a financial interest in or signature authority over a foreign financial account. If you checked no or left it blank and the IRS finds your foreign accounts through FATCA data, they now have a document in your own handwriting that helps build their willfulness case. Even if you didn't mean to lie, even if you didn't understand the question. The bottom line on Section 2, how you come into compliance and when directly shapes whether the IRS treats this as non-willful or willful. This is not a decision to make without an attorney. If you have unfiled FBARs and you're trying to figure out your next move, call us at 855-900-1040 or visit silvertaxgroup.com. We'll tell you exactly where you stand confidentially and walk you through every option you have. Section 3, what the penalties actually look like. For non-willful violations, the penalty is up to $10,000 per account per year. A recent Supreme Court decision, Bittner versus United States, ruled the penalty applies per return, not per account, for certain non-willful cases. That is a meaningful distinction. but it does not eliminate the penalty, and it does not apply in every situation. Do not assume Bittner protects you without having an attorney actually review your facts. For willful violations, the penalty is the greater of $100,000 or 50% of the account balance per year. On a $500,000 account, that is $250,000 per year. For 5 years of non-filing, you are looking at penalties that can exceed the value of the account itself. And beyond civil penalties, willful FBAR violations are a federal crime. Criminal prosecution is rare, but it happens. When it does, it carries up to 10 years in prison. I had a client, we'll call her Christine. She had 2 accounts totaling about $300,000 that she'd never reported. She had been putting off dealing with it for years. By the time she called us, she was looking at potential willful penalties that would have consumed every dollar in both accounts and then some. We were able to build a strong, non-willful case and get her into a streamlined program. She came out the other side. But had she waited another few months, the IRS had already started pulling FATCA data on accounts in her country of origin. That door nearly closed on her. Section 4, what you can actually do. You have 3 main programs available, depending on your facts. Option 1, the delinquent FBAR submission procedures. If you have no unreported income connected to the foreign accounts, the accounts were already properly reported on your 1040, you just forgot to file the FBAR itself. This program lets you file the late FBARs with a reasonable cause statement. Done correctly, this can result in 0 penalty. This is not available if you have unreported income. Option 2, the streamlined domestic offshore procedure. If you lived in the US during the non-filing years and have unreported foreign income, this program lets you file 3 years of amended returns and 6 years of FBARs and pay a 5% miscellaneous offshore penalty. That is painful. It is also dramatically better than a full examination. Option 3, the streamlined foreign offshore procedure. If you lived outside the US during the non-filing years, the offshore version of the streamlined program may apply, and in many qualifying cases, the penalty is 0. Here is the hard truth about all 3 options. They are only available before the IRS opens an examination. The day an IRS agent contacts you about your foreign accounts, every one of these programs is gone permanently. At Silver Tax Group, we evaluate which program you qualify for, we build your compliance strategy, we implement it, and we'll defend it if necessary before the IRS. No guessing, no fear. Just strong legal tax firepower on your side. Don't wait until the IRS comes knocking at your door. If you filed FBAR late or never filed at all, call us at 855-900-1040 or visit silvertaxgroup.com for a confidential review today. The sooner you act, the more options you have. And the more options you have, the better this ends. I'm tax attorney Chad Silver. If this video helped you understand where you stand, click like below and subscribe. I'll see you in the next one.